Hello everyone, welcome to SJ Learnex channel. In today's video, we are going to deeply understand oral evidence and the hearsay rule under the Indian Evidence Act. Section 59 of the Indian Evidence Act tells us that all facts except the contents of documents and electronic records may be proved as proved by oral evidence. This means that witnesses can come to court and speak about facts they personally know. Oral evidence is therefore one of the primary methods of proving facts in court. However, Section 60 introduces a very important limitation. It clearly says that oral evidence must be direct. This means the witness must testify only about what he personally saw or he heard or perceived through his own senses. If the fact is something that could be seen, it must be proved by a person who actually saw it. If the fact is something heard, such as a conversation or threat, it must be proved by a person who actually heard it. The purpose of this rule is reliability. When a witness personally experiences a fact, the court can test his truth through cross examination. The judge can observe his behavior, check consistency, and evaluate credibility. For example, if a witness saw the accused stabbing the victim, he can testify about that incident. But if he only heard from someone else that the accused committed the crime, he cannot testify about that as direct evidence. So the foundation of oral evidence is clear that oral evidence is allowed to prove most facts, but it must be direct and based on personal knowledge. The second hand narration is not acceptable. Now we go deeper into section 60, which is the heart of oral evidence. Section 60 says oral evidence must be direct. This means the witness must have personally perceived the fact through his own senses. The law recognizes five human senses, that is, seeing, hearing, touching, smelling, and tasting. If a fact could be perceived through any of these senses, the person who actually perceived it must come to the court. If the fact relates to something seen, it must be given by a person who saw it. If it relates to something heard, it must be given by a person who heard it. If it relates to something perceived by any other way, it must be given by a person who directly experienced it. This rule prevents distortion. When information passes from one person to another, there is always risk of misunderstanding, exaggeration, or false addition. The law therefore insists on first-hand testimony. Direct evidence strengthens fairness because the witnesses can be cross-examined. Cross-examination allows the opposite party to test the witness's memory, truthfulness, and consistency. For example, if a person says, I saw the accused running away from the crime scene, that is direct evidence. If a person says, my neighbor told me that he saw the accused running, that is not direct evidence. The first statement is based on personal knowledge, and the second statement is based on someone else's narration. So, the core principle of Section 60 is this: evidence must be first handed, witness must have personal knowledge, only direct testimony is admissible. This is the foundation that later leads us to understand why hearsay is excluded. Now we must clearly understand what hearsay evidence means. Hearsay evidence is second hand evidence. It happens when a witness does not have a personal knowledge of the fact but only repeats what someone else told him. In simple words, the witness is not speaking from his own experience, he is speaking from what he heard from another person. That is why it is called hearsay evidence. The basic problem with hearsay is this: the original person who made the statement is not present before the court. Therefore, the court cannot test the truth of that original statement through cross examination. For an example, if a witness says in court, Ramesh told me that Suresh committed the murder, this is hearsay. Why? Because the witness himself did not see the murder. He is only repeating what Ramesh told him. The real source of information is Ramesh, and Ramesh is not in the witness box. The court cannot ask Ramesh questions. The court cannot observe his behavior. The court cannot test whether he is telling the truth. That is why hearsay is considered unreliable. Let us look at another example. If a person says, I heard from people in the village that the accused is a thief, that is also hearsay. It is based on rumor, not personal knowledge. So remember clearly, hearsay is a second hand information. The witness has no personal knowledge. The original speaker is not before the court. Therefore, it is generally inadmissible. This is why Section 60 insists on direct evidence. Now, the important question is, why does the law exclude hearsay evidence? The main reason is absence of cross examination. Cross examination is one of the strongest tools in a trial. It allows the opposite party to question the witness, test his memory, detect lies, expose contradictions, and examine his credibility. In hearsay, the real person who made the statement is not in the court. The court only hears a repetition of what that person allegedly said. Since the original speaker is not available, the court cannot test his truthfulness. That makes hearsay dangerous. There are three major risks in hearsay. The first one is risk of misunderstanding, the second one is risk of exaggeration, third one is risk of deliberate falsehood. When a statement passes from one person to another person, details may change, words may be misinterpreted, sometimes unintentionally and their own assumptions. For example, A says, I think he may have been involved. B repeats it in a court. A said he was involved. The meaning changes completely. The Evidence Act prefers tested evidence, not rumors. The law wants evidence that can be verified, questioned, and challenged. That is why hearsay is generally inadmissible. Now let us repeat the example what I said. Suppose the person A says, like, I think he may have been involved. B repeats it in a court as A said he was involved. That is why hearsay is generally inadmissible. The rule protects fairness. It prevents conviction based on gossip, rumor, or unverified narration. So the logic is very clear. Evidence must be reliable. Evidence must be capable of cross examination. Hearsay fails these standards. Therefore, it is excluded. Important exceptions to the hearsay rule. Let us look at this. Although hearsay is generally inadmissible, the Evidence Act provides certain important exceptions to this. These exceptions exist because the law considers some situations to be reliable even without cross examination. The first important exception is res gestae under the section 6. This we have already discussed in the previous videos. You can maybe look at that video. Statements made during the transaction itself are admissible. The idea is that such statements are spontaneous and leave no time for fabrication. For example, if during an attack the victim shouts, Ramesh stabbed me, that statement becomes admissible because it forms part of the same transaction. The second important exception is dying declaration under section 32. A statement made by a person who is about to die regarding the cause of his death is admissible. The law assumes that a person on a verge of death will not lie. For example, if a dying person says, It was Mohan who poisoned me, That statement can be admitted even though Mohan cannot cross examine the deceased. Third, and confessions are also exceptions. When a person makes a statement against his own interest, the law treats it as reliable. There are also statutory exceptions like entries in books of accounts, statements in public documents, and certain official records. So remember this clearly. Hearsay is generally excluded, but when circumstances guarantees reliability, it becomes admissible. The law balances fairness with practically. This is why understanding exceptions in hearsay is very important. Now we will clearly distinguish between direct evidence and hearsay evidence. Many of us confuse these two in real life situations. Direct evidence is first hand evidence. The witness personally saw, heard, or experienced the fact. He is speaking from his own knowledge. Hearsay evidence is the second evidence. The witnesses did not personally experience the fact. He is repeating what someone else told him. Direct evidence is admissible under section 60 because it can be tested through the cross examination. Hearsay evidence is generally inadmissible because the original source of information is not available for cross examination. Let us see a similar simple comparison. If a witness says, I saw the accused stabbing the victim, that is direct evidence. If the witness says, my friend told me that he saw the accused stabbing the victim, that is hearsay. In the first case, the court can question the witness directly. In the second case, the real witness, the friend, is absent. So the difference is very clear. Direct evidence is with the personal knowledge and it is admissible. Hearsay evidence is second hand narration. Generally, it is not admissible. Now let us look at oral evidence and its importance. Oral evidence plays a central role in both civil and criminal trials. In criminal cases, especially, the prosecution often depends on eyewitness testimony to establish guilt. When a witness comes to the court and narrates the events, the judge not only hears the words but also observes the demeanor of the witness, body language, confidence, hesitation, and consistency. This helps the court assess credibility. Cross examination is a powerful tool. It allows the defense to challenge the witness, expose contradictions, and test truthfulness. This process ensures fairness and strengthens the justice system. In many cases, conviction can be based solely on the testimony of a single trustworthy witness. The law does not require multiple witnesses if the one witness is reliable and consistent. However, the strength of oral evidence depends on whether it is direct, clear, and free from contradictions. If the testimony is inconsistent or doubtful, the court may not rely upon it. So, the final understanding of this topic is oral evidence is powerful and central to trials. It must be direct and based on personal knowledge. Hearsay is excluded to protect fairness and reliability. This completes the concept of oral evidence and the hearsay rule under the Evidence Act. If you found this video helpful, please like, share, and subscribe. Thank you for watching.